Did you know that if there's something damaging or bad in your history that you want to keep out at the time of trial, your attorney can actually ask the court for permission to keep that information out through a special procedure? You want to learn what that's called and how he goes ahead and does that? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. That's known as a motion in limine. No, it has nothing to do with lemons. It's a fancy legal word which basically says, I'm asking the court for permission to take action and do something before the trial actually gets started. I'm actually asking the court to take a preventative measure because there's something in my client's background, there's something in my client's history that I want to keep out. And I want a ruling right now by the judge before we actually get started so that now the attorneys are on the same footing, they're on the same page, they know what can and cannot be said about this particular issue. And now, that's known as a motion in limine. What will happen is that the attorneys will now present this to the judge in oral argument before we go ahead and actually start the trial. Judge, I have a motion in limine about my client's history. Okay, counselor, what's the issue? Judge, my client was arrested and convicted 20 years ago about a horrendous crime that he committed. He served 10 years in jail as a result of the horrendous crime. Now, I want to make sure that the defense attorney is not allowed to go ahead and mention that whatsoever. Counselor, what do you have to say about that? And now the defense attorney is going to chime in and tell the judge how he thinks it's so important that this information be brought out to the jury and they should be allowed to evaluate it as far as this person's credibility. And now the judge will have to look at legal arguments, look at cases that have gone on before on this particular issue, known as precedent. And now we typically will have to give the judge some type of legal brief in support of our particular position to show why this type of information should not come in. He might even give the defense attorney an opportunity to now go ahead and do his own legal research and then bring it back to court the same day or the next day in order so that the judge can now make an educated decision about what to do about this particular issue. In some instances, the judge will actually postpone the trial for a day or two so that now he can get this legal information to make a legal ruling about this particular issue that was brought up before we actually get started. So now you know the process that occurs when there's something going on in your background or something damaging that we're now trying to keep out and get the ground rules before we start so that all the attorneys are on the same page. And now nobody blurts out during the course of trial, but Mr. Jones, tell us about your prior conviction. And now all of a sudden something that should not have come out has now been blurted out, which might taint and prejudice the jury. So why do I share this great information with you? I share it with you to give you an insight and an understanding to what goes on in these cases on a daily basis. You know, I realize you're watching this because you probably have questions or concerns about your own particular matter. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.